Hey real estate nerds, just a quick disclosure before we go into today's video. First of all, landlords hate having to do evictions. From an emotional standpoint, from a financial standpoint, it is awful. It's one of the worst things about, frankly, being a landlord. Not fun at all. It's not fun for any of the parties, the tenant or the landlord. Number two, most landlords are not wealthy. I'm going to repeat that. Most landlords are not wealthy. There's this idea that if you have an extra house, you are wealthy. That is not the case. The majority of our clients as a property management company who own houses own just one extra house, and many of them are military or whatever the scenario may be. They have a home they either couldn't sell or they decided to hold on to that to hopefully use as retirement in 30 years. But almost none of them have major awesome cash flow situations. You have a couple investor owners that are the exception to the rule, but the majority of them are not wealthy, have a mortgage, and if they don't remove the tenant from the property, they will go into foreclosure. So I just want to make that clear before we go into this video about evictions. We don't like it. It's not fun for anyone, and it's not really in anyone's interest to have to go through that. It is a last resort. Enjoy today's video. Hey real estate nerds, this is Alex Yoder with Pro Tip Tuesday, my favorite day of the week. And today I want to talk about evictions. Evictions in the new world, aka 2023, now that the legislative session has expired. Now, this has become incredibly complicated. You need to be talking to your legal counsel to figure out what you should be doing and how you should be doing it, because you do not want to be several months into an eviction only to find out that you did it incorrectly and you now have to restart the entire thing. So there are two things that landlords need to be aware of, and I'm going to do my best to make it clear as mud, but again, you need to be talking to legal counsel. This stuff is very confusing and I may not articulate it perfectly, so please make sure that you're doing that. So number one, for those of you who don't know, we now have the CARES Act returning to Colorado. And then I guess number two, I'll be talking about House Bill 23-1121. And those are the two things that are kind of changing the new dynamic here as it pertains to evictions. But let's talk about the CARES Act first. So the CARES Act was basically written during, in response to the pandemic, basically telling landlords, hey, you need to give your tenants who are not in compliance a 30-day demand to cure or quit, instead of, in most cases, what would have been a 10-day demand. And there are some exceptions, 5 days and 3 days for other things. I'm not going to go into that right now, but normally you're giving a 10-day demand. However, because of the CARES Act, we were temporarily giving a 30-day demand. Well, after COVID, most courts returned to 10-day demands. They wanted to see that we were doing 10-day demands. However, there were 2 or 3 in the state of Colorado that were still interpreting the CARES Act as not expiring because it wasn't, frankly, written particularly well. And there was a court hearing that challenged that, saying, hey, this was clearly in response to COVID. Those remaining 2 or 3 courts need to get on the same page as the rest of the state and accept landlords doing 10-day demands. However, that was not successful, and in fact, it flipped the other direction with the Colorado Supreme Court saying, yeah, it actually wasn't written very well, and it did not expire, and now all courts in the state of Colorado are returning to 30-day demand as the required notice period if they're going to allow you to evict somebody, which is, in my opinion, pretty crazy and very, very frustrating, because they were in a hurry to write a bill to help people. Now they are hurting landlords indefinitely until it gets reversed, revoked, or whatever. I know there's some fights on the federal level, but we'll see how that goes. But in the meantime, we are posting, by and large, 30-day demands on tenants. Now, the exception is if you basically own the property outright, or you have a mortgage which is not federally backed, then you can do a 10-day. But for 90% of the rest of us who have mortgages on our properties with mortgages that are federally backed, we are going to be posting 30-day demands. And we actually started doing that last month as a management company at the advice of our attorney after the onset of the Colorado Supreme Court's ruling. So that's the first thing to consider. Make sure you're posting the correct demand, and check and make sure that you do or do not have a federally backed mortgage if you have a mortgage on your property. Again, if you're free and clear though, you can just post a 10-day. Okay, so let's talk about House Bill 23-1121. This is basically labeled the Eviction Protections for Tenants Bill. And effectively, I'll read this word for word. If the tenant is receiving supplemental security income, Social Security disability insurance under Title II of the Federal Social Security Act, or cash assistance through the Colorado Works program, then there are two things that landlords need to do. Number one, or two big things. Number one, if a tenant, so let's walk through this. You post a demand notice, the tenant says, hey, I fall in one of these three categories. They are entitled to mediation, not paid by them. And the bill basically says that tenants can't be charged for it, and landlords are only obligated to pay half of it. So Lord knows where the other half is how the other half is being paid, but since we're required to do this before we can evict, I'm assuming we're paying for that as landlords. And I know that in Colorado Springs specifically, there's some grant money there at the court level that helps pay for that. So for now, it's being paid by these grants. But anyway, so you'd be required to perform mediation before you could file for the eviction. Now, ideally, you can do that inside of the demand window, whether that's 10 or 30 days. Probably not going to happen inside of 10 days, but hopefully you can do that inside of 30 days. So as soon as that's over, if payment has still not occurred, you can proceed with the eviction. So that's number one. And really quick on that, the tenant has to indicate that they fall in those categories. You're not going to just assume anything. If they don't indicate that they have a right to that and that they fall in those categories, we've been told that you just roll forward as normal. Number two, typically when you get a judgment for possession, like you go to court, the judge says, yep, you win, you can evict them. Typically, you wouldn't be able to execute on that writ for effectively 10 days with that tenant. So you couldn't schedule with the sheriff for a date any sooner than about 10 days out. But with these tenants, if they fall in that category and they say they fall in those categories, you can't execute on the writ for 30 days. So the judge has said, you're right, they didn't pay, you can evict them. You have to wait an entire month before you can actually physically physically perform that eviction with the sheriff on site. So those are the two big things to know. As far as the mediation and that in this bill, there is an exemption for owners with 5 or fewer properties, but I'm going to tell you, if you feel like you may be entitled to an exemption, make sure you're talking to the attorney, because you don't want to be into it and find out that, oh, I didn't actually qualify. And now you got to restart the whole thing. Make sure you have your ducks in a row. And frankly, eviction attorneys are not expensive. They do evictions in bulk. You know, they may be doing 20 or 30 of them, or however many they're doing all at one time, and so they can do it for cheaper. Typically, I guess for just ballpark, typically we're paying between $400 and $600 to perform those evictions to our attorney. So just to recap, the CARES Act, make sure you're posting the correct notice. House Bill 23-1120, which you should go read. Go Google that, look it up on the Colorado General Assembly website and read through it, and or talk to your attorney for the 20th time about what you should be doing with that. The other thing is that both of these things, the CARES Act and HB 23-1120, have disclosure requirements. So with the CARES Act, your attorney should be giving you an affidavit that you're going to post with the demand notice that says these are your rights under the CARES Act. And for 23-1120, we've been given a paragraph that we input into our 10-day demand or 30-day demand template. Now, some attorneys are having property managers or landlords post an entirely separate page for this bill, while others are just giving you a paragraph to add into your demand posting. and time will tell which one works the best as these things adapt and change over time. So hopefully that was clear as mud and gave you some idea of evictions in 2023 and going forward until further notice. And I'm sorry for the bad news, but it is becoming incredibly complicated, incredibly time-consuming, and incredibly expensive to remove tenants from properties who are not paying. So it just is a reminder that we should make sure we are screening people as well as we can within the bounds of the law, and make sure we are trying to work with people if we can. I know most landlords do that anyway, but if the tenant needs an extra month and they're agreeing to vacate voluntarily, that may be to your benefit versus trying to forcibly remove them and waiting 3 months or 4 months or however long it takes, depending on the scenario. So hopefully this was helpful. We'll see you next week.